one.
Good afternoon, and thank you for appearing to give evidence. Alex Thomas and Dr. James Vitali. Is that the right pronunciation?
Yes, that's correct.
Good, thank you. Today we'll be considering the future of retained EU law, otherwise known as assimilated law, because the law has been changed to call it that. This is the final session of our current inquiry, and we will be focusing on how the reforms have been undertaken to date and how they should be undertaken moving forwards. We will look in particular at the political and official level structures that are required to ensure reform is efficient, effective, and allows us to harness the full opportunities of Brexit. So before we get started, and those watching at home, would you mind briefly introducing yourselves? If I could start with Mr. Thomas first of all, and then Mr. Vitali, Dr. Vitali.
Thank you, and thanks to the committee for inviting us to appear. My name is Alex Thomas. I'm a programme director at the Institute for Government. The IFG is a non-partisan think tank looking at how to make government more effective. I've been there for about 4 years, leading our work on the civil service and policy making. Before that, I was a senior civil servant in the Cabinet Office, DEFRA, and briefly the Department of Health.
Thank you. Dr. Vitali.
Good afternoon. Thank you very much for having me. And Mr. James is absolutely fine. I'm head of political economy at the think tank Policy Exchange. I cover a number of briefs there, from economics to housing, but I'm also responsible for our re-engineering regulation programme.
Thank you very much. So I shall ask the first question. Now, the reform of this law, now known as assimilated law, otherwise known as EU retained law, involves nearly every government department because it covers all functions of all departments as they have been affected by EU law as it was made since 1972 onwards. So I want to put that into context. It's a huge amount of law. Primary responsibility for this project now sits with the Department for Business and Trade, and I think it is a bit of a mystery as to why it should be one department when in fact all the other departments are also affected, and there are cabinet ministers for those departments as well. So my first question is it unusual not to have central coordination, and including, by the way, with expert legal advice and specialised understanding of these matters from the Cabinet Office, which has overarching responsibility for coordination between government departments for a project of this nature and scale? I mean, what's your take on that general proposition for a start? I'll ask Alex Thomas to go first.
Kick off, yeah. Thank you. I don't think it is unusual in general for a cross-cutting policy or a policy that requires coordination across government to sit in an individual department.
Is it wise?
Well, I'll come to that in a moment if I may, because I think there are obviously all sorts of government policies, both sort of substantive and coordinating, that sit in line departments, and if you put everything in the Cabinet Office or in the centre, then that in the end is sort of leads to confusion and incoherence in the Cabinet Office, as we've separately argued. I do think, though, two sort of fairly healthy caveats to that, which comes to your question of wisdom, Chair. One is it reflects political priorities of the government of the day. Now, you can take a view on whether retained or assimilated EU law is or should be a political priority of the government of the day. But I think the fact that it sits in a line department, you can reasonably infer from that it's lower down the list of government priorities than those things that sit at the centre. I also think, casting back to before the European Union referendum, there was a secretariat in the Cabinet Office, the European and Global Issues Secretariat, explicitly dedicated to the coordination of government policy on Europe and global issues. Had that still been in existence, I would imagine that this sort of policy area is something that would find itself in that bit of the Cabinet Office, because it is a classic cross-departmental exercise which, as Secretary of State for DBT quite admirably sort of acknowledged, it does require the authority of the Cabinet Office to crack heads and to get Secretaries of State engaged.
If I may just butt in at that stage, there is a fundamental question as well, which is quite unusual in this context, and that is that the whole corpus, the whole sphere of EU law was the law of this land until it was repealed under the Withdrawal Agreement Act, etc. And therefore, the abolition, as set out in the Retained EU Law Act, of the entirety of that law and all its principles and the role of the Court of Justice and everything that goes with it, takes you into much deeper roots and much deeper questions, so that the reason why, one might ask, it was important to get this right and to have that degree of central coordination, not necessarily direction, but the necessity to ensure that the focus of government departments, having regard to this massive, effectively revolution that was taking place in the abolition of the supremacy of EU law, putting that into effect, takes it into another realm of importance. Would you not agree?
Well, which is a good argument for why it would be a priority for the government and therefore drawn into the centre of government. So I think I don't, I'm not sure you made a sort of a qualitative argument for why it would be impossible to do that from the DBT, but that is a good argument for its priority. But I think perhaps putting what you've said in a slightly different way, one of the reasons I would be keen, if I was advising the Prime Minister or the Cabinet Secretary, for this to be a programme that was run from the centre, is, to your point, there are all sorts of quite profound consequences for Northern Ireland, for regulation across the Peas, that you can only really take a policy view on from the centre of government. So
you have to have consistency on that principle you've just enunciated.
Yes,
between the government departments, because you can't have one bit which partially abolishes the supremacy of EU law and another one that doesn't.
And on the substance of it, and I think take Northern Ireland, some of the questions around Northern Ireland or some of the questions around the government's overall approach to regulation. There was a reason why, back in the day when I was a fairly junior civil servant, the Better Regulation Executive sat in the Cabinet Office, because it was because it reached into all different parts of government. So I do think, and I'm sure we'll get into it. I would agree, if it is the committee's emerging view that, or fairly clear view, that the Retained EU Law programme is one that reaches deep into cross-cutting policy issues, and those are best managed from the Cabinet Office. I would say that that is the case.
And one further point I would ask you about, if you agree with me, and do feel free to jump in, Dr. Vitali. The interaction of the Retained EU Law, which is effectively the change, there are statutory duties laid down to report, and they have to report every 6 months, and we're coming up to another one in July. So far, it's been pretty, as the committee has made clear, so it's not exactly, it's an open secret, this. We are not satisfied with the progress, nor are we satisfied on the face of it from the evidence we've had, with the intention to do it fully and properly, comprehensively. It also, if I may say, has impact in the context of whatever could end up in the Supreme Court, for example, on any of these matters, in that, just to use paragraph 144, for example, of the most recent judgment of the Supreme Court on the Rwanda Bill in relation to the interpretation of statutes. Now, if you're going to repeal legislation, you have to do it properly, and you have to do it in a manner which is express and unambiguous, because otherwise the Supreme Court will take a view that they can continue to interpret it, and I won't go into all that case law, but fundamentally Lord Reid said it is the duty of the court to give effect to a statute, irrespective of another treaty or other provisions in law, providing the words that are used are unambiguous and clear. That is common ground for decades, generations. So we don't want to be in a position, do we, to put it in the frame of a question, in which there is any doubt about that, when you're changing the body of law and creating a new statute book when there was a previous one governed by different principles. Could you comment on that, please? First of all, Dr. Vitali.
Well, you forgive me, I was going to go back to the question that you set us off on, if that's okay, Chair. And I wouldn't disagree with anything that's been said thus far. The only thing I'd say is you've already heard evidence that broadly the fact that this portfolio is in DBT is a historical accident. It travelled with Sir Jacob Rees-Mogg when he went over to the department. But just from a regulatory reform perspective in particular, I do think there are some problems with that. We have recommended in papers in the past that the responsibility for this agenda should be in the Cabinet Office, because we see broadly that there is a lot of divergence between how different departments are approaching the regulatory reform agenda. The Treasury has carve-outs for areas which it is responsible for. And I think, too, the fact that it's placed in the Department for Business does obscure the fact that the regulatory reform agenda as a whole isn't just about business. It's very important to the public sector too, and the provision of public services. I think Policy Exchange would stand by the recommendations we've made already, that this should sit in the Cabinet Office.
And generally speaking, without sort of inviting you to go into all the details, do pretty much agree with my assessment as I put it to you in the form of a rhetorical question, which is that basically this is really important, and it's underestimated that it's a job that needs to be done as comprehensively and efficiently as possible to deliver, and I quote now from something you said, Dr. Vitali, the repatriation of regulatory sovereignty post-Brexit offers an immense opportunity for the UK. However, this is an opportunity that as of yet has gone unrealised. Lawmakers urgently need to think more strategically about how Britain can enhance its regulatory framework to support the growth of the British UK economy and deliver better outcomes for the people. You stand by that, I take it?
Yes, and maybe we'll get an opportunity to talk about that more shortly. But I would just say that, as Mr. Thomas said, that clearly this is a political question too. Whether it's prioritised from the censor is the judgment that the government of the day makes.
And that, very, very briefly, if I may, Chair, I think to your rhetorical question, I would make 2 points, both I think broadly in support. One is there is clearly there is a job of coordination to be done. I have no doubt that officials in DBT are doing a perfectly decent job at recording and coordinating and sort of getting the cross Whitehall machinery to do the basics. There is a decision on that machinery of government question, if you like, about whether that should sit in the Cabinet Office in the centre or not. On balance, I would say, personally, I think it probably should. And that would be my advice to a Prime Minister or a Cabinet Secretary. But that's not a sort of, that's a question of judgment and is a sort of practical question. The more interesting thing, and I think you've got into these questions both in your rhetorical point, as you described it, and in some of your questioning of previous witnesses, there absolutely does need to be, unequivocally, a controlling mind in government taking policy decisions about some of these sort of deeper level policy questions, some of which you highlighted. Whether that is the Secretary of State for Business and Trade with a cross-government remit, whether it's a Cabinet Office Minister, whether it's the Prime Minister, him or herself, I think is a reflection of political priorities. But the question, the point you alight on is that there are fundamental questions of policy that need to be taken in a cross-government way. And if the Secretary of State for Business and Trade does not consider herself responsible for those questions, then there's a gap, and that's a problem.
You've seen the questions I asked her, and I've also made it clear that it seems to me a good idea, if that system was to be changed, albeit late in the day, to give more coordination. And I don't think I had any pushback from the Secretary of State when I put that point to her, and in subsequent conversations with her herself as well. So that is that one. But in relation to the extent of the law, I just mentioned quickly and ask you again, as a matter of principle, if you're thinking about laws that ought to be integrated across government departments by coordination through the Cabinet Office, one of those sets of laws would be the chapters in the old EU law statute book, if you like, on Home Office law and immigration law. And just to mention one example, in the Rwanda judgment itself, the President of the court specifically disallowed one of the claimants on the grounds that the Immigration Act of 2020 had engaged in the repeal of existing EU law to such an extent that actually the claimant's claim was dismissed by the court on the principle that it was clearly stated, and this is the most recent judgment of the Supreme Court on this issue, that the legislation had been removed, repealed, his case was undermined, and therefore his entire case was dismissed. So we're talking about the Supreme Court's attitude to this as well. That's really the point I wanted to make. And it's a good precedent, and it's a very recent one. So I invite you to comment briefly on that before I move on to Greg Smith.
Only to say that I think, I agree, and when I was saying there's a sort of structural but also a psychological effect with placing responsibility for, our whole approach to the laws and regulations and directives we inherited from the EU in the Department for Business and Trade, it's sort of a siloing of something that is far more comprehensive for the way that government works in the UK. I'm no expert on the Home Office and immigration, but I take your point entirely.
That's all I'm saying. Okay, Greg Smith, please.
Thank you, Chairman. Afternoon, gentlemen. I think a lot of the things I was going to ask you've neatly teased out in your answers before. But on top of the official centralisation, almost certainly within the Cabinet Office, that really you've both said would be preferable in dealing with rule, there is this gap of political oversight as well. To quote the Secretary of State when she appeared before us, she told us, the fact that I am the one who has to answer all the questions on retained EU law takes the pressure off other ministers because they think it's someone else's problem. Do we actually need, hesitate how to put this, do we actually need a single Secretary of State or at least minister to coordinate from the centre? Or would it be better done as a cabinet committee, or would it be better structured from within number 10?
Let's try. Reading the Secretary of State's evidence to you, I agree she was admirably candid from the committee's perspective on that. If I was doing my former job of Principal Private Secretary to the Cabinet Secretary and worrying about collective responsibility, I would have emitted a small groan. But it's to the it's a testament to the committee's work that she was able to say that. And I think it is illustrative of a wider point in government. As I said in answer to Sir William's questions, I do think it would be better coordinated from the Cabinet Office, but I feel less strongly about that than the fact that somebody, some minister is responsible and accountable for taking those important policy questions. I see there's no constitutional or other or practical reason why that couldn't be the Secretary of State for Business and Trade, other than it is harder for her, as she acknowledged, to reach into all the other departments in order to be able to crack through the policy questions that are relevant to those departments, which is why I would put it in the centre. We have, though, talked quite a lot about only doing at the centre what can only be done at the centre, and so there is a risk that you, as I suggested earlier, you overload the Cabinet Office with hundreds of different kind of coordination jobs. But to Sir William's points, this is one of the reasons why the Cabinet Office exists, is to do this form of coordination. Whether it would be a minister or, you would need, wherever it sits, you would need a minister to be responsible for this, and then they interpret their responsibilities as according to their own judgment and conversations they may have had with the Prime Minister and others. But there would need to be, if it sat in the Cabinet Office, a Cabinet Office minister. You can read quite a lot into how a government feels about an issue depending on the seniority and nature of the ministers that it puts in charge of these things. So if you really wanted to crack heads together across Whitehall, it would need to be a fairly senior minister, and it would also need to be someone who had the unequivocal authority of the Prime Minister to do that head cracking. Otherwise the system doesn't respond to it. Question of a cabinet committee or not. I mean, yes, it would be useful, but cabinet committees are only really useful insofar as they reflect the political dynamic that is and the prioritisation and the policy questions that are going on. So fine, but if it was a cabinet committee that rarely met, then it wouldn't have that much use other than a kind of technical way. The final thought on that is I saw in the previous evidence, quite a lot of discussion of czars, and I couldn't resist sort of getting on a hobby horse, which is sort of czar is meaningless in Whitehall speak. That could be a minister, that could be an external figure, it could be a very senior civil servant. So I think the question to examine in that is less the kind of, is it a minister, is it a czar, is it an official, but to get under the skin of that and think about what their authority is over other government departments.
But from your experience in government, what we did hear from Department of Business and Trade officials in our evidence is that there is allegedly this cross-departmental monthly meeting of officials, but it doesn't seem to have any actual structure. From your experience in the civil service, can you actually get anything done by bringing a group of people together on a fairly ad hoc monthly basis with no actual structure to guide them?
You're inviting me to say no, but I'll say, I'll say, having sat on many such bodies in my time, you can, but what you can't do is resolve those fundamental policy questions. So absolutely, the impression I got from reading the evidence from that session was this was a perfectly functional body. It's producing these 6 monthly reports that you're scrutinising, but it is only designed to crunch the numbers, to coordinate, to hear reports back from departments and to progress chase on where they've got to on certain things. It would not, as a committee of civil servants at that level, without political oversight, be empowered to make those kind of policy trade-offs and decisions that go to the heart of some of the issues that the committee's been exploring.
Do you have anything to...
Sure. One of the other things that the Secretary of State talked about in her evidence session was a sort of demand-led approach. I think this ties into your question, actually, because, I mean, as a way of gathering information, it seems perfectly fine to me. I don't think that's where the problem is. The problem is once you've got that information, have you got the structure in place to actually get some movement and pull the right levers? And that's a separate point. Two other things I'd say is sort of hypothetically, is a sort of mental exercise. You could imagine a situation where the incentives for departments were strong enough that you could have each of them competing against each other for delivery on regulatory reform. But I don't think that's the case. And I think that's because broadly this agenda is a deeply political one. Lots of people see regulation as the thing that sits between them and quite substantial risks in whatever part of their life. And so that case for why regulatory reform is important needs to be done from the centre. And that sort of speaks to the point that the Secretary of State was saying that she was covering for other ministers by coming and taking questions when they didn't require to, or weren't required to.
Yeah, thank you.
Yes, so if I can now move on to the next question. Brendan Clark-Smith, please.
Thank you, Chair. Good afternoon, gentlemen. So the government seems to be measuring the success of retained EU law basically based on how many of them that they've actually been dealing with, sort of either revoked or reformed or so on. Do you think this is the most appropriate way of measuring it, or is there a more substantive, measurable outcome that we should be looking at, really? Alex, do you want to start with that one?
Yeah, sort of never mind the quality, feel the weight kind of thing. I think it is obviously interesting to see how the statute book is changing, and the numbers are not, the numbers are relevant. It's worth tracking them. I think not least to hold departments accountable for the things that they've said they're doing in general terms. But no, I think it's I don't think it tells us very much about the policy questions that we've been talking about, or the relative importance of different pieces of legislative change. I mean, as the committee said, previously, you could have a single line of something that was of profound importance to all of our lives in this country that barely registers on a sort of heat map or chart that you've been scrutinising, and then you could have 1,000 changes that are largely irrelevant. So, but you don't need me to tell you that. I think you've explored that already. As to whether there's a better way, I find it hard to do anything other than the judgment of ministers, parliamentary committees. I don't think you can obviously disaggregate the different areas, the different sorts of changes that are being made. I think you could reasonably ask, I haven't looked at the 6 monthly reports in huge detail, but from flicking through them, I think you could reasonably ask for a bit more sort of quality disaggregation and filtering of that, and a bit more information. But in the end, it will be a judgment based on the consequences of individual bits of legislation.
Because when it was originally obviously almost flipped over rather than it all going in one go, I think the sheer capacity of it was outlined in terms of the quantity of it, and therefore I think it would be a reasonable expectation that there would be more attention paid to that. James, what's your perspective on it? Is it the same as Alex, would you say?
Broadly speaking, I mean, I think an objectively better way to have measured this would be to have at the start made a qualitative assessment of the regulatory reforms that would have the most bang for buck. You would say that these particular ones have this size impact on the economy, these single line repeals less so, and then you would have targeted them. But I think that relies on a whole load of things being in place. One is the impact assessment system, and there's been research that's come out recently about the quality of that, and the fact that the incentives to actually do it well the first time and get a good reading on the scale of the impact of individual pieces of regulation, that they're not there. And that hampers the work of a government that's looking to work out how to deliver good outcomes. I mean, the better regulation framework is about an outcomes orientated approach, but you can only really do that if you've got a good sense of the scale or the cost of each individual regulation that you're looking to repeal.
Thank you, Chair.
On that question, I don't know whether the general public knows this yet, but I'm given to believe, and there's a report in the press yesterday, that there's going to be a white paper tomorrow, and furthermore, that it is going to claim that there are 500 more laws, a quality of which we do not yet know, and that's the real question to which you both answered. The other question I'd just like to throw into that equation is the problem that exists, which goes back to my earlier question about the coordination of our statute book. I think we got a slide. Sorry about that. The one thing that's concerned me a great deal is to have two statute books. And the abolition of the supremacy of EU law as a matter of principle doesn't alter the words that are used. And those words that are used in a given law are actually quite often the result of consensus in the case of EU law, which goes back to 1972, when there might have been serious differences between the government and the other member states, but for the sake of not wanting a row, they agreed that they would adopt a provision which otherwise would have been lost by majority vote, because everybody knew before they went in the room what was going to happen. So the consensus was really very artificial, and it not necessarily in British interests at all. So a lot of this law is not what we wanted necessarily or at all, and therefore that raises a question. But if you're left with a whole body of law in your statute book, which has been translated by the draftsman into what appeared to be UK law, but actually was EU law, then if you've got one lot of that law being interpreted according to the principles of EU law, because the wording takes you in that direction, rather than because they've said they have abolished the notion of supremacy law, so the in actual content of the law is not what we would have wanted, then of course you're in a very difficult situation, and you can't have two different statutes or two different books of statutes. You must have one so that your Supreme Court and all your other courts can actually adjudicate on the same footing. So I wonder if you might like to comment on that as a proposition. First of all, Alex, with your great experience, if I may say so.
Nowhere near that of this committee. I certainly don't want to hold myself as an expert on EU law or anything else. It's more the sort of process and systems of government. But I suppose the first thing to say is, I mean, a word in favour of to sort of slightly react to some of the language that you use there, and in favour of the or to recognise what goes into a consensus in the EU laws. I know this isn't the point of the committee, but I mean, in my experience, the UK did normally get its way, actually, and where things were traded off, they were traded off for other national interests. But I know that's the sort of side point to the point you're actually making. I suppose the UK government would argue that there is one statute book now, even if it's held in different places and arrived at through different means, and that it will be for the courts and successive governments to pick their way through that. I can see that the consequences of different laws having been arrived at through different processes and then incorporated into the statute book may very well create problems of interpretation and so on. My suspicion, though, is that where that creates my expectation would be that where that creates a major problem or a big flashpoint, government, ministers, the UK Parliament, exercising its sovereignty, will address those inconsistencies. I suppose it's the slightly sort of more under the bonnet grinding of gears, things that never quite get political or policy attention to them, where problems might arise. But of course, it's a novel situation.
I don't have much to add except for the fact that that last point, it should have shows a slight maybe tension between the retained EU law agenda and the regulatory reform or the law reform agenda, which is that if you have an outcomes approach, then it's the ones that Mr. Thomas described as flashpoints. Those are the ones you would focus on. Whereas if it's the case that you want to sort of transform the law comprehensively and translate into a type of law that is sort of more appropriate for the UK, that's a separate point, and it might be in tension with the first, with the more outcomes oriented approach.
Reynolds has argued, as you know from the work he's produced, and it's quite extensive and somewhat magisterial, I would say, the problem of having a common law book is actually incredibly important. So common law is actually central to this. Do you have a view on that?
I would agree, but I think I'm trying to sort of suggest that maybe that has an ideological bent to it, which has a different set of imperatives to the regulatory reform agenda. Okay.
So, David Jones, some questions, please.
Yes, Alex, you're the co-author of a report by the IFG entitled Power with a Purpose. And that report recommends clear priority setting at the centre of government, with each priority, and I'll quote, being accompanied by measurable outcomes and a lead Secretary of State alongside other contributing responsible Secretaries of State. And it also talks about the need to monitor performance against priorities, to hold ministers and civil servants to account for delivery, and to maintain a shared information picture across the centre and departments from which performance analysis could be drawn. I was going to ask you how the government's exercise in reform of assimilated EU law measured up against that model, but I think I can infer what you're going to say. But what I'm also interested in is, what other recommendations or findings from your report do you think are relevant to our consideration in this committee of how reform of EU law could be improved?
Thank you, and thank you for the reference to the report, Mr. Jones. I mean, to answer the question you didn't ask me, but I think it reveals a sense of what the government's priorities are, because the fact that retained law, assimilated law sits in DBT, there isn't a strong presence at the centre. That's the inference you can clearly draw from that. That said, it's...
Well, you make the point, don't you? There should be clear priority setting at the centre, and you've repeated that in your evidence today.
Yes, indeed. And this... I suppose there is a sense in which this is about policy ends, but it's also about policy means. And so if a government was coming in and setting its priorities, would I expect them to put the process of retained EU law sort of absolutely front and centre? No, I would expect them to put the policy questions that, whether it was regulatory reform or questions around immigration, that William was referring to earlier, or whatever. But then you need to hold the mechanisms for those priorities at the centre, which, say, the current government is not doing. Other points from the report. I mean, I think there is. You mentioned measurement and evaluation, and clearly there is an evaluation mechanism associated with this subject area, but from the work that the committee's done, you've highlighted important gaps in that evaluation, in that process of evaluation. So that's one further lesson I would take. Another is about the role of the Treasury. There is a danger when you're being inside government or talking about government to blame everything on the Treasury and sort of use it as the bogeyman outside the room. But I do think if you want, one of the points we make is that in the absence of setting a clear strategy from the centre, the Treasury's set of priorities can often take over, and spending reviews, you de facto set government priorities through a spending review, for example. And so on a process like this that has such potential importance for the economy, for policy across spending decisions across a range of departments, there is an interesting question to me to how far the Treasury is embedded in this process, and I suspect not very much is would be the answer.
There's a very major gap.
Sorry?
It's a very major gap.
Yes. And one of the main thrusts of that work that we did around the centre of government was the importance of, basically harnessing the power of the Treasury in order to get stuff done. We came out against splitting the Treasury for various reasons that are probably a bit off subject, but it is, it's essential that the Treasury is embedded in any major programme the government adopts, and that does seem to be something of a gap here. I also think, and this goes to the priority setting, I suppose, but the value of translating the political or manifesto or whatever objectives of a government into a meaningful programme for government, which on one level is a sort of stating the obvious, but I think governments too rarely take the time at the start of their administration, whether it's a change of prime minister or a change of party, to properly apply their priorities to the kind of craft of governing, whether that's setting out the legislative programme, how they design systems and structures. And it does go to some of the points that we've been talking about this afternoon. I'll stop talking about that report because I could go on for too long.
James, do you want to add anything to it?
Yes, just on...
It's not your paper, but...
Yeah, I know. And
please feel free to criticise.
It was free advertising. But just on the evaluation and measurement point, I feel like perhaps we are an international outlier in some respects, because we don't... Again, this comes back to the point that we don't really know the nature of the beast we're trying to tackle. Lots of other countries have a sort of fairly regular inventory of their stock of regulation, wherever it comes from, so long as it applies. I think Germany has one called on DEA or something like that, and it has the impact assessment on the website. It has the estimated cost of it. It's net cost. So it seems strange that the UK doesn't really have an equivalent. We do have this dashboard, which is fairly useful, but again, it doesn't give much granularity to the costs and the impacts of individual regulations, and so therefore it's quite difficult to measure and evaluate because of that, that lack of granularity.
And isn't there a further problem in that bits of retained EU law or assimilated law keep sort of flopping out?
Well, that's true, and of course for a number of regulations that derive from the EU, which applied in the UK, there wasn't even an impact assessment in the first place. They've obviously, impact assessments were given for directives, but not for regulations, and they're sort of coming from out the back of the sofa as we go through this process.
Simply complicates matters. Thank you very much.
Okay, and just to sort of wind up on that side of things, Are you saying, in a nutshell, that you can see a case with the appropriate authority of the Prime Minister, to go back to Alex's point, because ultimately, because of this coordination thing, you need it from the centre as well, with your full authority, that there is a case to have a dedicated retained EU law minister, on the basis that through that process, with the assistance of the Cabinet Office for Coordination and the authority of the Prime Minister, you can achieve both consistency and the outcome, which is the objectives, which are needed to promote the kind of things that James has put forward in his own work, in his own way, in his own report. In other words, if it's a big enough subject to deal with, let's do it properly. Let's use the resources that are needed, and you may even need to have some external advice, as in the case of Hogan Lovell, who have been brought in at £4 million a crack to advise on these questions. But I just wanted to finish that question off by asking you that question about the dedicated retained EU law person as to run it.
Yeah, I mean, absolutely no question that you need a minister to be responsible for this, because otherwise it's sort of floating unmoored from policy and political ministerial oversight. The question of whether you need a dedicated minister is about kind of ministerial bandwidth and the support that they have. I suppose I'm more interested on this subject in the authority and central backing of that minister than whether they're dedicated and solely spending their time on this subject.
I rather suspect that if the minister is given the job by the Prime Minister, the two things run
one
together.
reflects the other, yeah.
Sammy, would you like to come in, please?
Just before I go into the main question, I want to ask you, the evidence we have been given so far from the last sessions, but first of all, this issue has been shuffled around 4 different departments. There's no central control through the Cabinet Office. The Minister told us she was unable to control the agenda of other departments, and really they're depending upon other departments to see through the programme. It depended on the Minister's agenda, and she had no control over that. There had been no 3 departments, I think she mentioned, had no change at all. There had been very few changes even in the departments that there were available had done so at the moment. Even her own department sat between 3 people, and when asked about a dedicated minister, her answer was that not many people want the job. Does this strike you as, and this is important for Northern Ireland actually, does this strike you as an agenda that this government's even serious about?
I think it goes back to what I said previously about it reflecting, the revealed behaviour reflects the priorities of the government. I think if you ask the Prime Minister or any of the senior ministers in the government whether they were serious about this agenda, they would say yes. But the actions around the organisation of the departments that you've set out there suggest that it's not as much of a priority. I guess the argument that often comes out, and it has merit, is that on subjects like this you want it to be mainstreams, to use that dreadful word, or kind of embedded in the day-to-day policy of departments. And there absolutely is merit to that DEFRA and the Secretary of State and DEFRA is responsible for identifying the benefits and dealing with the risks of a programme like that. You wouldn't actually want the Secretary of State Business and Trade getting deeply into the detail of an environmental policy that wasn't relevant to her brief. So that's fine, and it is right that the Home Office is on top of the immigration law consequences. But where the gap is in those the things that can only be determined cross-departmentally. And so, to use a phrase I think I used earlier, there clearly is no controlling mind actively taking a view on some of these cross-cutting questions. If, to the extent there is, that is the Secretary of State for Business and Trade, and one of the reasons her evidence to your committee was so striking was that she was pretty clear that she didn't consider herself to be that controlling mind.
What you did say, though, was that it seemed to be driven in a demand-led approach. What are the pros and cons of doing it on that basis?
I'll start, then you.
Sure.
Pros and cons. The pros are that issues are emerging that are genuinely of concern to businesses or lobby groups, pressure groups of whatever form. You're not. It goes back to some of the debates around the original form of the retained EU law legislation. You're not setting kind of deadlines, arbitrary deadlines for change, for something to happen because the government's set out a particular objective. The cons, from my perspective, are clearly that government is there to govern, and if all you're doing is reacting to the almost certainly incoherent demands of competing groups, then you're not you're not actually setting an objective and a set of priorities about how to do it. So, I mean, clearly, both operate in our system. For the thing to work, both need to happen. But if you want to make progress on a policy program or area, then you can't be completely demand-led. Government has to put itself on the front foot.
On the pro side, there's the obvious point that if you don't have a good grip, because your ability to assess the impact of particular rules is impaired, having market participants or something like that to feed into government is obviously really important. It might only be anecdotal evidence about the impact on a particular business, but that's still useful, and it's something that Policy Exchange has recommended elsewhere, that feedback loops can be really, really useful. But I entirely agree. The point of regulation is that it needs to balance a number of competing imperatives, from consumer protection to growth to competition to innovation. And it's my concern is that the balancing, doing that balancing, is being outsourced to people who don't have the competency nor the kind of elected mandate to do that. So a sort of demand-led approach is very good for trying to get a sense of where the issue is pinching, but in terms of carving a regulatory framework that is the best for the British economy, for the British people post-Brexit, that has to be done by politicians. It can't be done by regulators, nor can it be done by market participants.
I wasn't on the committee when the Minister gave evidence, but when I read that, it did give me some concern, because in the Safeguarding the Union deal, which the government did with my party leader then at that stage, one of the commitments which were made, and indeed there have been regulations that have gone through the House, is that ministers would be obliged, when looking at any change in regulation, to first of all make an assessment as to whether it would lead to regulatory divergence between Northern Ireland and GB, to report to the House, and then to make a decision. It didn't mean that if there was regulatory divergence they couldn't overrule that, but to make a decision. And the implication was, of course, if there was going to be serious regulatory divergence, then the change shouldn't be made. Is there a danger, if this is demand-led, that the Minister has already been convinced by whatever circumstances or lobby groups or pressures within the department, officials bring this to his attention, that by the time a decision is made to change regulations, the argument is won, that whether there's regulatory divergence or not within the United Kingdom, the Minister has been convinced that this change is necessary? Or am I misinterpreting that? And is there still the opportunity to back down if it's demand-led?
Yes, I mean, Northern Ireland is really interesting because it does represent one of those points where regulation, which can be quite technical and dusty, does become a flashpoint and political. I suppose my answer to your question is that doesn't seem to me to be a structural problem; it's a political one. If the ministers is concerned about the health of the internal market, if they're concerned about the union, and they prioritise that, then there shouldn't be a problem. The only structural dimension, I suppose, to it is, and it came up in the evidence session with the Secretary of State, is she frequently felt quite reluctant to comment on things that she felt were reserved matters or devolved matters. And that wouldn't be such a problem for someone housed in the Cabinet Office, because the person who's responsible for the union is the Prime Minister. So that would probably be the only structural dimension to the question you pose, but really it's about political priorities.
I agree with that. I'd also say this is not something that is confined to this subject or to any of the different aspects of the questions that you asked. It is very common, and actually it's one of the pros of the demand-led system is that ministers are exposed to all sorts of ideas and are persuaded of the merits of things, and then it is in the end yes, most civil servants can advise, but it is in the end Parliament's job to put the stops on something if that is the view of Parliament. I do think there's the particularly interesting point on this subject matter is what some of the powers that the government has took under the retained EU law legislation to potentially make certain changes without full legislative consideration. So you're sort of you're taking me in the direction of the concerns around the pretty sweeping secondary powers that the government took there. I'm not an expert on those at all, but I would say that the more that governments do that, the more that scrutiny suffers, and the more likely you are to end up with poor policy decisions put into statute.
And are there other policy areas apart from the programme on retained EU law where this demand-led approach is apparent?
I think you could say it across almost any policy area, and particularly any area where the government as a whole or an individual Secretary of State doesn't have a particularly strong forward agenda. So I think of some of the areas where I was responsible when I was director for animal and plant health in DEFRA. Michael Gove and then Teresa Villas and George Eustace had clear objectives on, say, animal welfare, but in those areas where in those parts of the animal welfare debate where the government didn't have a clear perspective, things were just sort of coming in. So I could you can pick almost any area, I suppose.
May I give one example, if that's all right, Chair? A really good one is nutrient neutrality, and that broadly was demand-led. I think it was something that the housing sector itself has been, flashing lights and saying to the government, look, this is a real problem. There's hundreds of thousands of homes that are being held up by this inherited piece of regulation. But it does sort of speak to the point I think both of us have been making, which is that the reason why reform of that particular regulation didn't go through had nothing really to do with the structures. It was the political process, and it was the failure of the government to communicate over a sufficiently long period of time what the benefits of that reform would be, and what the balancing was to be done between risk and delivering houses. It just shows that it really was a political rather than a sort of structural issue.
Yes, so the last question I will put myself, which is to follow on very directly from what Sam has been saying, because I think I can say without fear of contradiction that this committee is very concerned about the situation in Northern Ireland and has been from its inception of the whole problem, and I don't think there's any chance of that changing. But we've been hearing evidence that the reform of retained EU law should promote the health, competitiveness and productivity of the UK internal market, and that actually the Northern Ireland dimension is immensely important in the context of the United Kingdom. So what potential is there for the reform of retained EU law to cause divergence within the UK internal market? And will the Commons framework be an adequate tool to manage that divergence? Alex, Alex go first and then James.
Again, I try to approach the subject with humility, being not a deep expert on any of those areas. Clearly, the UK internal market is of fundamental importance, the Northern Ireland questions, but also across the whole of the country. I suppose, yes, I do think that the retained EU, the sort of the process that we're engaged in on translating retained EU law does have the potential to create difficulties, tensions, flashpoints, divergent regulatory systems across the UK, and that is because we're making a series of changes through that programme, but that's no different to other regulatory divergence or policy decisions that the different administrations across the UK might take, although perhaps particularly exacerbated by the political decision of, as I know you've discussed, the Scottish Government to stick to EU law, and a political imperative for the current UK Government to find opportunities to diverge from that retained EU law. So as again, it's a theme, it's the politics rather than the mechanics. On common frameworks, again, some humility as not an expert, it seems to me to be a perfectly reasonable model, but as ever, it requires some pretty serious political investment and senior official investment to make these things work, because they can very easily fall into abeyance. So I think the kind of the nature of the frameworks is fine. I know that there have been parliamentary reports suggesting missed opportunities and things, which I would I think agree with. But there is a sort of perfectly reasonable, though no doubt can be improved, administrative structure there. But it comes back to the politics and how far divergence is pushed through that.
I wouldn't disagree with anything that's been said. I'm not sure I've got loads that's original to offer. Just 2 points. One, I just come back to that point about if you want to institutionalise union considerations into this process, then it would be more easily done in the Cabinet Office where the Prime Minister sits as well. And I've entirely forgotten the second point I was going to make, which is probably helpful to the committee. Yeah.
I mean, in the context of what I said at the beginning, that the evidence we've received that reform of retained EU law should promote the health, competitiveness and productivity of the UK internal market, in which we also observe very strongly that Northern Ireland is subject to EU laws in relation to the single market legislation. We find that pretty astonishing, actually, and I don't think any member of the committee would disagree with what I've said. Having said that, this is about the economy of the United Kingdom, where it really matters in terms of, and would I be right in thinking that you would agree or disagree, that the object is to serve the interests of real businesses, including small and medium-sized businesses, which take up 85% of the British economy in terms of productivity and its activities, and also the customers themselves. So we're talking about the entirety of the British people engaged in their commercial activities, small, medium-sized businesses, bigger businesses as well. All these things are affected by the laws that they're governed by, and therefore, if the object is to promote the health, competitiveness and productivity of the UK internal market, we want that to be as good as possible. It sounds almost ridiculous to ask the question, but actually the real question is, does the retention or the failure to eliminate the consistency that we have been listening to the witnesses for the last several months amount to, that the UK internal market does need to be improved, does need to have regulatory arrangements which are helpful. And to go back to James's original point, that when you were talking about the importance of the purpose of doing this at the very beginning of the session, are we in fact going to see that as a result of the changes that are going to be made in the next report, which is going to come out quite soon, the white paper. Do you have any anticipation as to what that's going to contain? And David would like to come in as well.
There's just one point I want to make. Looking at it from the outside, as you are, do you perceive any time pressures at play in this exercise that we're discussing this afternoon? Or are things just drifting along? And would it be helpful if time pressures were introduced, if that's the case?
I suppose a couple of points there. To Sir William's point, I take no view on the benefits of kind of regulatory consistency. The tidy-minded former bureaucrat that I'd like to think I was would like consistency, but I also recognise the benefits of different rules in different parts of the country. So sort of stay on the fence on that. But clearly, do businesses and everybody else in the country deserve a well-managed process and a statute book that is understandable and explicable? Of course, yes. On the time pressure point, I suppose I'm a bit Goldilocks. I was very pleased when the government decided to remove the deadline for all retained EU law dropping, because I fully subscribe to the Secretary of State's argument that meant that the civil service and ministers were engaged in a frantic damage limitation exercise rather than actually focusing on the regulations or other laws that the government wanted to change. The quid pro quo of that is that they do then set out clearly what they want to change and get on with it, if that's what they want to do. Perfectly legitimate position to say, well, let's just sort of keep all these things as they are. But given they said government needs a bit of urgency, but it also needs the time to consider and reflect so you don't make silly mistakes. So, you heard that there's kind of 2026 aspiration for this programme to finish. I suppose it's quite hard to tell from the outside, but that feels sort of reasonable but slightly on the slow side. But
Well, 2 points there. One, it does seem to me, from my perspective, rather slow. But secondly, it is an aspiration, and it's not a deadline. And is it not the case that, in the absence of deadlines, then drift inevitably creeps in?
Other things tend to take priority, is how I'd put it. So I don't think it's. I would be very surprised if there was any sort of conscious desire or attempt, particularly on the part of the DBT officials, to drift. But of course, if you've got a hard deadline on one thing and a softer deadline on another, then I know which I'll prioritise.
That's exacerbated, is it not, by the absence of a dedicated minister solely focused on completing this exercise?
Yeah. Yes.
If I may, just on the time pressure point, you simply can't time pressure a government into changing its political priorities. If it's a political priority, it will invest in it and it will front load it. And actually, I think we've sort of seen the reverse effect. If sometimes government departments feel like the sort of a sunset clause is going to force them to do something by some point, they'd much rather delay it and just and not really delve into the detail. On the political opportunity point that the chair raised. One thing I just want to submit to the sort of committee to consider is I do think there probably is going to be a tension, and it's already evident, between this better regulation agenda and the Brexit opportunities agenda, because I think they're measured by different yardsticks. When it comes to Brexit opportunities, it's the quantum of regulations that we can translate, reform, repeal, whatever. But the better regulation project is something different, not necessarily more comprehensive, but it's about improving the way that our regulators work in the future, making sure it delivers better outcomes for businesses and British citizens. And really, if there's a question of priority, there will be a trade-off between saying we need to focus on the number of European originating regulations, or really focusing on ones where we're going to get the most bang for buck in the economy. Which is not to say that it shouldn't be a priority. It definitely should be. I think in the fiscal environment we have, there's not really much cash to spend on government priorities. Regulatory reform is one of those really important policy levers that can be pulled to stimulate productivity growth.
Again, would not forgive me, Chairman. Sorry. Again, would not a dedicated minister be in a better position to manage the tensions that you just described?
Certainly, none of this is a comment about personalities. I think the Department for Business and Trade are doing a good job. It's just the fact that where they sit and not being in the Cabinet Office, that has some implications. They have to spend political capital getting movement in other parts of the government, which the Prime Minister, for example, or the Cabinet Office might not have to.
One very brief further point, sorry, and it is mildly off topic, so forgive me, but I couldn't resist the opportunity. We published a report last week about the scrutiny of regulators, and I do think that Parliament as a whole could spend just a sliver more time focusing on the scrutiny of regulators as well as the scrutiny of regulation and how regulations are applied. So I'm abusing the platform to
No, you're not,
that.
actually. I think you're saying something very important. And just to bring this to a conclusion, I don't see a real difference between better regulation on the one hand and having a proper statute book that operates according to the principles of a better economy and more accountable democracy. I don't see that there is a problem there. And I think that what David Jones was saying about having a dedicated minister does make sense for that reason. And I think, in a nutshell, we're very grateful to you for coming this afternoon. It's been very interesting. And we'll be reporting, but of course we've got to wait till we see what they say themselves tomorrow in the white paper, and how many laws they are going to get rid of, and whether it's quantum or whether it's quality. And that's going to be a very key question. So thank you very much for your coming today. Thank you.
Pleasure. Thank you for having me.
The proceeding has ended.